Welcome to Learn Short and Typing with Vikas Sir. Exercise number 4 and 5. Fifth. 840 words, 80 word per minute. So be ready. Start. According to the appellant, the order of the High Court is clearly wrong on several counts. The order passed by the High Court dated 9/3/2005 convicting the appellant for contempt of court has also been assailed in criminal appeal number 491 of 2006. The trial court came to hold that since the child had remained with the appellant for a period of 7 years, he appears to have made every possible effort to obtain the custody of a minor. The learned district judge took note of the fact that taking of the child from his father's custody may adversely affect the sentiments and upbringing of the child, but at the same time the child should not be deprived the mother's home. Para. Stand of the appellant before the High Court was that the court below had not held that he suffers from any disability in his role as a father, and therefore there was no comprehensive reason for the court to direct custody of the child to be entrusted to the respondent. The fact that the respondent was the mother cannot be the sole basis for allowing the petition. While considering the prayer for the custody of the child, several factors including the relationship between the parties and the minor are secondary. It was submitted that the minor was abandoned when he was about 1 year and 9 months old. Thereafter, in the garb of seeking custody, several rounds of litigation were unleashed. Para. He has a large income and resides in a joint family where the minor is taken care of by the appellant, his mother, brother and brother's wife, and his 3 nephews. Stop. The warmth of the joint family has led to an all-round development of the child, and by taking him away from those surroundings can deprive him of love and affection. The appellant lives in a position locality and the house is built on nearly 3,000 square yards, whereas the respondent resides with her parents in a 2-bedroom flat. Apart from that, the appellant has a good educational background, and since the child has been residing for the last more than 7 years with him, the courts should not have directed handling over custody to the respondent. Next para. It was further pointed out that the primary focus being the welfare of the child, the respondent should have brought on record as to how, with her meagre income, she would be able to provide good education to the child. It was pointed out that the child is afraid of his mother, and wrenching him from the custody of the father would lead to irreparable mental trauma. Next para. So far as the dismissal of the applicant's appeal bracket against the orders in respondent's application D9 of 1993 for custody bracket close for default on 10/6/97 and the refusal of the High Court on 4/7/1997 to restore the same, we have been taken through the affidavits and the circumstances of the case, and we are satisfied that the High Court was not justified is not restoring the appeals and the in refusing to give a hearing. It appears to us that the High Court did not give due importance to the fact that the case related to custody of a child who has been living with the applicant for more than 12 years or more, and that it involved a serious consequences for the child, whatever may be the fault of the applicant. It was a fit case where the appeal should have been restored if the child, on account of his supervision in the 3 days with his father during the pendency of the appeal, when temporary custody was given to the respondent, was not willing to accompany the mother to the High Court. Prima facie, it appears to us that there was no ground for initiating contempt proceedings against her for not producing the child. Be that as it may, the said contempt proceedings will be disposed of in accordance with law by the High Court. Stop. In any event, we direct recall of the balance warrants issued against the applicant if they are still pending. Next para. Before the hearing of the case, we interviewed the boy in chambers and found that he was quite intelligent and was able to understand the facts and circumstances in which he was placed. He informed us that he was not inclined to go with his father to USA, and he wants to continue his studies in India in the completes 10-2 or he finishes his graduation. He feels that he will then be in a position to decide whether to go to USA for higher studies. He wants to continue to be in the custody of his mother. He told us that his desire is to become a veterinary doctor. Parties and counsel on both sides wanted us to dispose of the custody matter on merits. The High Court, while holding that the applicant had no case on merits, has given only one reason for granting custody to the father. Full stop. स्टूडेंट ये आपके 840 वर्ड्स है, इसको आप टाइप कीजिए। टाइप करने के बाद आप इसको मैच कीजिए। आपको पीडीएफ आपको डिस्क्रिप्शन बॉक्स में मिल जाएगी, उसमें आपको टाइप करना है। थैंक यू वेरी मच।